government instrumentalities, because that's the biggest problem we all have with everything that's going on. Everybody thinks they have to have a government. Well, first let's start out with govern. Stands for and the first two words, to direct. That second word, it's not a word, it's a term, and it's direct. Di meaning dual, two. Rect meaning rule, meaning there's two rules at play when you deal with governments. Governments, when they project these two rules, they only tell you one set of rules and try to convince you that you're subject to that set of rules. And that's the problem. You have to realize you are not under the direction of the government unless you place yourself there, in which they will direct you to one set of rules, which they have bifurcated and hypothecated. If you're not following the law and you subject yourself to the legislative written law of man, you are in fact being directed under your own consent. This is why so many people are in prison, in jails, because they don't comprehend this. When we think about the government instrumentalities, it states clearly through the government instrumentality doctrine that anything instrumentalized by the government is not taxable. So let's talk about government instrumentalities. What are the government instrumentalities that we know of today? Well, first let's look at the Title 18 of the United States Code, which is their government rules. And it tells you right there, obligations and other securities of the United States, while remembering United States is the corporate entity under the 11th Amendment, where they speak of Congress. There's two Congresses. There's a de jure Congress and a de facto Congress. And we are talking specifically about the de facto Congress. The de facto Congress works on the concept of the House of Representatives. The House of Representatives is where a bill is placed to be passed and then sent to the Senate in exact form to be passed again, so that it then can be approved by Congress. And when they enter these bills into the House of Senate, they are strictly commercial bills, contracts. Whereas if they enter it through the Senate first, then it's actually from the de jure side, and again, it must pass the House bill, which is commercializing the law. So either way you go, when it goes to the Congress, it's being instrumentalized as a commercial contract. And we see this under the federal regulations or federal acquisitions regulations, which if you look at Title 48 of the Federal Code of Federal Regulations, again, the government instrumentality, and it says specifically 48 CFR 52.212-5. I quote, contract terms and conditions required to implement statutes or executive orders. And it's got a nice little hyphen. And it says commercial items. And when we see that hyphen, it means with. So statutes and executive orders can only be implemented with commercial items under contract terms and conditions. That means every federal regulation and every state statute is a commercial contract, period. No ifs, ands, or buts about it. And that contract is using a financial instrument known as an obligation or other security of the United States. Now, what are these instruments? A lot of times we think about instruments as financial when in fact they start out as documentation. And when we start out with a document, such as a letter from a court saying that you're supposed to go to court on this such and such a date because somebody's brought a claim, that is a government instrumentality. See, all the courts are judicial. Judicial. That sounds government to me. It is. Because it's a judicial branch of the government that is imposed upon those that need government. Not people such as myself. We're not under a direction. We follow along with that which created us because we are strangers and sojourners in this land with him, as it states in the Bible. That is what I follow. Now, if they want somebody to follow a direction, they're going to give you things like, well, you're going to go up here to this intersection. There's going to be 4 different intersections, and you're going to want to go this way. But they don't tell you about the alley or this option or this option. They only tell you the direction they want you to go. So we have to be diligent in our research to find out those other avenues, those other ways and means of following the path that we really wish to follow. And this is further explained if you look through all of their codes. Nowhere will you see any of their codes talking about entrepot, entrepot, which is the exact opposite of import and export, of which they tax under the contract on the internet for the international sale of goods through a government entity. Therefore, they are instrumentalizing imports and exports, taxing them. When you have a right to be able to have that, whatever is being imported and exported, put at your door, placed at your door, free of taxation, simply because you have an independent private contract between yourself and another man. They have no right to interfere as a third-party intervener. The problem is people don't realize how to affect this in their own life because they've been under government direction for so long. Their parents have been under government direction for so long. It's been going on for eons. And we really have to escape that. We have to realize that when they place documentation in front of us saying that we have to go to court, it's just documentation, okay? It hasn't been actually instrumentalized. It's only being presumed to be instrumental from their side because their threats, duress, and coercion are expected to have you go to that court. So when you certify it by signing something, then you certified that documentation is now a financial instrument. Again, however, still an obligation of the United States because they are the ones that in fact instrumentalized it as a document before it was certified. And though, again, they instrumentalized it under threats, duress, and coercion, they are still obligated. Period. This is why if you're going to go to court, do it with no fear. Do it with knowledge. So you can point these things out. There's a premise that you shouldn't go to court, and I agree with it. You shouldn't. You really shouldn't. You should do it off the paperwork. But if you're forced, the old sheriff comes to the door and puts you in handcuffs because of a fraudulent warrant, which they are all fraudulent, which I'm going to get a case and show you here when we're talking about this judicial legislation and legislated word and everything in regards to certifying and documenting instrumentalities. They are still obligated because they instrumentalized all of those documentations, and they do so in fraud. And this is a relatively recent case, and it's still, in fact, ongoing, I believe. I don't think there's been any actual settlement in this case yet. And this is a brother in kind that's been fighting this battle for many years. And they actually put fraud charges on him, put him in prison. And he's sitting in prison trying to fight those fraud charges, which he is, in fact, innocent because the government instrumentalized this stuff. And we're going to read this, and it says, recently, a criminal complaint and petition was filed in the District Court of New Jersey, Trenton Division, accusing District Judge Frida L. Wolfson of obstruction of justice and requesting the release of a federal prisoner based on the contention that the judge had no authority to sentence anyone to jail. And this is accurate according to my information. Like I said, they're instrumentalizing the courts, the judicial courts. They are instrumentalizing that and producing documentation and certifications. Witnesses get on the stand and testify, and it's all instrumentalized in fraud against a live man. Judges are presumed to know the law or where to find it. And if I can find it, but they can't, that's on them. That's on them. In prepared remarks by Attorney General Jeff Sessions on September 5th, 2017, Sessions stated, as the Attorney General, it is my duty to ensure that the laws of the United States are enforced, United States, and constitutional order is upheld. The Constitution is not an order. until someone indentures it. And then you, as the participant, have to place the order. Otherwise, the other party is, the opposing party is going to place their order. And if you don't know how to rebut their statements, then their order becomes true, in fact, on the record, because you have not rebutted it. So the presumption rides. And that's all it is a presumption, because you can still rebut it if you gain that knowledge. Says, so again, the Constitution is just the Constitution as it is. When he says constitutional order is upheld, that means somebody has to place an order on the Constitution. They have to indenture it. They have to create the trust. They have to recognize the trust and place themselves as either the beneficiary or the grantor. Or if you're strong enough, place yourself as the trustee. You realize your power in this stuff, people. No greater good can be done for the overall health and well-being of our republic than preserving and strengthening the impartial rule of law. The impartial rule of law. Societies where the rule of law is treasured are societies that tend to flourish and succeed. The petitioner David Molesky, a former chiropractor and pilot from Neptune, New Jersey, claimed he was falsely imprisoned when the judge in his criminal trial on mail fraud and wire fraud charges sentenced him to 54 months in prison, followed by 5 years of supervised release, as well as a $10,000 fine and more than $48,000 in restitution. Because of the false imprisonment, Molesky's lawyers requested the immediate release of their client. The argument presented in the complaint suggested that Judge Wolfson obstructed justice pursuant to 18 U.S.C. 1512 because she knew in advance that she had no authority to prosecute, adjudge, or imprison. Read that. 18 U.S.C. 1512. Attorneys for Molesky and other social justice groups thoroughly researched the issue and found that the law granting district court judges the authorization to send any defendants in any criminal case to prison is invalid because the bill that passed the House in 1947 did not match the one that passed the Senate in 1948. Remember what I just said about a bill being passed appropriately has to be passed in Senate to become law, and then the House in duplicate exact form, and then presented to Congress for approval. Congress approved a bill that wasn't in exact form. It went to the Senate as a bill of law, and then to the House, and the House did not pass it according to the Senate. They changed it. Why did they do that? Because they had to make it a commercial contract under federal acquisitions regulations. That's the way this government works. It says the Senate is supposed to enact a bill, but then the House is supposed to pass it in exact form in order for it to be approved properly. Otherwise, it's not correct. And it's in on and for the record. You people can look at these bills and see that the Senate bill is not the same as the House bill, and therefore this law, in fact, is invalid. You can validate that part of it yourself. It's in, on, and for the public record, part of public domain. They cannot deny this, yet they continue to do so because people can't point it out. If Public Law 80, this is the public law that came out of it after Congress approved it, they had to write the public law side. Public Law 80-772 is indeed not valid. Then Molesky and presumably thousands of other prisoners were sent to prison illegally. Excuse me? Let's correct that right here now. They were sent to prison unlawfully. These people committed executor days on tort. It's a criminal act in common law, and each and every last one of them is subject to the identical sentence that they pass down. If not a more severe one is procured appropriately for those measures. So if a judge sentences you to 5 years, and it's more appropriate to sentence that judge to 20 or 30 years, that's the sentence he gets. If he sentenced you to 20 years, but according to the law, he's only subject to 5 years, then he's still subject to the 20 years that he sentenced you. Period. The argument presented in the complaint suggests that Judge Wolfson obstructed justice pursuant because he knew in advance that she had no authority to prosecute. That's because she is to know the law. They presented this back to her. She evidently didn't research it or did the research and just ignored it. Either way, she has a fiduciary responsibility as a trustee under a grant of authority. She has been directly placed in a trustee position under that grant. That is in the language. If she has been granted, then she has either been granted as the trustee or the beneficiary. And she certainly isn't a beneficiary having somebody else administrate the case. She is the one administrating the case herself, therefore she is the public trustee in direct violation of international trust law, Clayton antitrust laws, all of it. And this is Nuremberg Code stuff too, people. This is a very serious issue because it would mean that no federal judge currently has authorization to sentence anyone accused of federal crime to prison. It would call into question any criminal case in which a person convicted of a federal crime was sentenced to incarceration. Now, I want you guys to understand that if the federal can't impose this, then the state has no ability to impose it either. So therefore, state or federal. Let's clarify that. This isn't just federal crime. This is state crimes. Traffic violations, custody issues, non-payment of fines, fees, and penalties, everything. Remember, fines, fees, penalties, those are the same things as levies. Levies include taxation. So they are like kind with taxation. And because it's an instrumentality of government, the doctrine says you can't tax people. And whether you want to call it a tax by calling it a fine or create ambiguate it by calling it a fine, fee, or penalty makes no difference. It's still a tax upon the people. Period. President Trump signed Public Law 80-772 into law on June 20. Excuse me, not President Trump. President Truman signed Public Law 80-772 into law on June 25th, 1948, just prior to the final printing and publishing of the Uniform Commercial Code that was already being enacted and legislated through the various different states. And then it finally came to a quorum of legislation within the states and was then proposed to the House of Representatives to make it uniform through all 50 states. Because at that point, they only had a quorum of states, a majority of the states. And therefore, they took it to the Congress on the federal level, or the Congress, and then the Congress sends it down to the House or the Senate, depending on who they determine the law goes to. They sent it to the House to have them pass it. The House passed it, then the Senate passed it, and then it went to the Congress. After their passing, Congress approved it. That was in 1950, was when the UCC came into final effect on the federal level. It was being effectuated through the practices of each of the 50 states beforehand, until it finally got the quorum of states to legislate it so they could pass it to the federal level. Thus, ostensibly rewrote Title 18 of the United States Code. However, a different bill passed the House in 1947 than passed the Senate in 1948, rendering the law unconstitutional. Every court action, I don't care what level it is, I don't care if it's family court, I don't care if it's juvenile court, I don't care if it's bullshit court, because it's all bullshit court, and I don't care if it's international court. The instrumentality of a government over a people is not to be taxed. Until the Senate and the House pass the exact same bill, and the bill is signed by the president, or the bill is not signed and becomes law without signature because both houses pass the bill, then there is no law. So, despite the fact that Truman signed it and Congress approved it, doesn't mean it's law. That's only what they did to convince people that it was law, when in fact it is not. Just because the House of Representatives voted to pass a law that does not make it enforceable law without passage from the Senate as well. So when they presented the bill, again, it has to be in exact form, otherwise it's not the same bill. So all you had is a bill passed by the House in 1947 and a different one passed by the Senate in 1948, and then they have to get together and negotiate a combined or compromised law for passage of both houses, that before it can become law or the law dies. Remember the old Schoolhouse Rock song about "I'm just a bill on Capitol Hill"? Yeah, go back and watch that little cartoon and realize what they did here. They did not pass the same bill. See Article 1, Section 7 of the Constitution. So before we go on and finish reading this, let me get my Constitution. This is another important factor, people. This came up because somebody asked me about the certification of electronic communications and stuff. And this is what we need to do, people. We need to keep things in definitive paper form, because when they start transferring all the records to electronic form, the computer machine programming itself can change the terms and conditions within. And realize all of these electronic programs have what's known as security certificates in the program. So your electronic signature becomes a security certificate through the Treasury, period. They're converting your right to have a definitive form, an absolute substance, into electronic form in a language that you can't read, thereby taking their legalese and converting it even further, watering it down, diluting it, so you have a harder time comprehending what it actually says and does. So realize this, people. Start printing your stuff off. Make sure you have it in definitive form. I've got all kinds of paperwork, particularly the transcripts from my last trial. And they don't like that. $1,500 is what they want to try to tell me. Excuse me, isn't that a tax? I believe I have a right to that free of charge because I am a party to this. And I will not allow you to instrumentalize it against me. Period. You have rights. Start asserting them. Anyway, it says, Article 1, Section 7. We go to Section 1. It says, all bills for raising revenue shall originate in the House of Representatives. Remember, I said anything that has to do with commerce starts in the House of Representatives, and anything that has to do with actual law starts in the Senate. But the Senate may propose or concur with amendments as on other bills. So right there, it takes international law to the Senate, saying that they can propose international or concur with international law, or concur with amendments as on other bills. Like I said, if you indenture this, it becomes your bill. You are making the order. Every bill which shall have passed the House of Representatives and the Senate shall, before it become a law, be presented to the President of the United States. If he approve, he shall sign it, but if not, he shall return it, and with his objections to that House in which it shall have originated, who shall enter the objections at large on their journal and proceed to reconsider it. If after such reconsideration 2/3 of that House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of that House, it shall become law. But in all such cases, the votes of both houses shall be determined by yeas and nays. Holy Bible brought in right there. Let my yea be my yea and my nay be nay. You will not instrumentalize any government financial debt instruments against me. They are not taxable against the live being. And the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. This is why I say you have to indenture this. You have to get a copy of this. Amend it to your needs. Sign it. Send it in to them for confirmation, just like you would through the House. Send it to the President, send it to the Congress, and have them confirm that your amendments are true and concur with the amendments already stated. You're just placing clarifications as to the direction of which they go. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law. In other words, when you send it in and there's no response in 10 days, it becomes law as stated. In like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Unless the Congress by their adjournment prevent its return. Congress adjourned sin die in 1861. There is no valid Congress today because Amendment the 11th Amendment supporting that there are two various Congresses. One of them walked out sin die. The de jure walked out sin die. The only Congress we have operating today is de facto. An instrumentality of a government itself, not an instrumentality of the people. In which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary, except on a question of adjournment, shall be presented to the President of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and the House of Representatives according to the rules and limitations prescribed in the case of a bill. Read that section, people. Realize that this is your case. This is the case of a bill that you can amend and then send to the state and federal levels for authentication. Once it's authenticated, you have your law. Not unrebutted, but authenticated. Comprehend that. This is how you instruct the government in which direction they are to take in accordance with your capacity. You're the grantor. They are the grantee who grants the state and federal judicial system their trustee positions. Period. So we'll finish on with this case. Where we left off, it says, see Article 1, Section 7 of the Constitution. And it says, the next part, Title 18 also includes 18 U.S.C. 4081 and 4082, which authorizes the transfer of federal criminal judgment from the U.S. District Court to the Department of Justice, and then from the Department of Justice to the Bureau of Prisons, of which they hire nothing but private prison corporations. Period. There is no prison in this land that is not privatized. This is what they're trying to do with the police forces. They're trying to privatize the police forces too. Most of them are already privatized. That's what this electronic thing's getting to. They're disambiguating the language, or ambiguating the language so you can't comprehend it, so they can slide it in there without you knowing. Let's see here. However, 18 U.S.C. 481 or 482 are not in the statutes at large and do not exist as a matter of law. So where did they pull this shit out of their ass? No transfer of judgment is possible, rendering any imprisonment impossible. Researchers looked at numerous memos from House and Senate clerks. House and Senate clerks, meaning both houses, like I said, are commercial under the 11th Amendment de facto. Even though the Senate is supposed to be projecting law and the House is presenting commercial contracts, anything that goes through the Senate is in fact with the intent of being converted to a commercial contract, because that's the only way the de facto government can operate. The only way. Researchers looked at numerous memos from House and Senate clerks, and they all confirmed that the bill that passed the House on May 12, 1947 was different from the one that passed the Senate in June 1948 and went to Truman's desk. Now, that says all of them. There was no rebuttal whatsoever. They all confirmed that yes, those two bills were not the same. So again, do not believe the government. Do not believe me. Do not believe these researchers. Go look at it for yourself and see for yourself. And again, provide more proof that it is not the same. According to the argument in the complaint, Public Law 80-772 positively repealed the previous laws granting jurisdiction to district court judges, which means district court judges effectively have no jurisdiction to either classify defendants in the Bureau of Prisons or to hold them at all. That bailiff has no jurisdiction either. The sheriff has no jurisdiction either. The police have no jurisdiction either. No one has jurisdiction except yourself. Which means district court judges in other words, based on their research, even if a judgment was considered valid, judges have no authority to send anyone to prison. This is why we have a requirement for a trial by jury. Otherwise, the instrumentality of a government has no effect because it is merely commercial. And this is directly related to equity. Equity. You can only be partaking of equity if you bring equity. Everything they bring in their commercial system is a commercial contract and therefore proven not to be equity. It is a tax. It is going to cost. It's going to cost you your time to prepare documentation, do the research, counsel with other people, all of that. It may not be a commercial taxation, but it taxes your time, and that's the expense. They're taking away your time, your efforts, your labors, in which you could be spending it with your loved ones. In love. The recent complaint makes the claim that Judge Wolfson's acceptance of indictments and the issuance of orders in Molesky's case are legally void and thus constitute obstruction of justice because 18 U.S.C. 3231 was never legally passed by Congress, and neither 18 U.S.C. 4081 nor 4082 and valid sections of statutes at large. None of it is valid. And this is stuff that's been researched and brought to their attention, and yet they refuse to acknowledge it. In addition, they claim the denial of a motion to dismiss on September 13, 2014, filed by Molesky's case, is obstruction of justice because both the House and Senate failed to properly pass the same version. Wolfson is presumed to know that, particularly when they did their research and presented it to her, and she refused to acknowledge it. UCC 1-202, notice and knowledge. They gave her notice and knowledge. That's their performance. They performed. She's required to pay them. She's required to compensate them. What does that mean? She's required to pay attention. This is not entirely a new argument. As early as 2008, the Bureau of Prisons received a large volume of requests for administrative relief because of the claim that no law currently exists that grants jurisdiction to district court judges to transfer those convicted of a crime to prison or jail. Jail is imprisonment. In 2008, Harry Lappin, then head of the Bureau of Prisons, asked the number 2 person in the Department of Justice to investigate the claims.